I am in Hackensack, New Jersey, and I was a magistrate judge for a while. And as far as those of you listening to this most likely are concerned, I am an adjunct faculty member at Georgetown. And go ahead, Judge.
Hi, I'm Craig Shaffer. I'm United States Magistrate Judge for the District Court in Colorado. I've been a magistrate judge now for 9 years. I'm also an adjunct faculty member at the University of Denver School of Law.
So you wound up with two professors here today talking about electronic discovery. And what we thought we would chat a little bit about is what we think attorneys need to do these days if they want to go into litigation. And with that, why don't I turn it over to you?
Yeah, I have become increasingly convinced over the years, as we are trying fewer and fewer cases, as we're confronting the reality of the disappearing civil trial. Lawyers, and particularly trial lawyers, are really now finding themselves fighting most of the litigation battles at the pretrial phase. In my opinion, that necessarily means that effective advocates have to not only be concerned about their case, they also have to be actively involved in case management. It's not enough just to be a litigator, you now have to be a manager.
There is a lot to be said about managing litigation. If you look at the Federal Rules of Civil Procedure, Rule 16b gives enormous discretion to magistrate judges and district judges to shape the outlines of a case. Now, with the amendments to Rule 26F of the Federal Rules that went into effect in December of 2006, attorneys are encouraged to focus on the things that we're here to talk about, electronic discovery and evidence issues. And there's a great opportunity through the rules and through conferences that attorneys have to have with each other before they go to conferences to try to work out some type of staging or phasing of litigation if you can, so you're not swamped in the first instance by every type of problem that might arise.
Ron's exactly right. When I think of case management, what I think is, I think that lawyers have to take a proactive approach to their case, and they have to be proactive from the outset of litigation. eDiscovery in particular poses so many challenges and involves so many potential costs that you can't afford to make it up as you go along. If you fail to take a proactive approach, particularly in the eDiscovery area, you're going to find that you are presenting problems to the court at a point in the pretrial process when we have little ability to assist the parties, when our options are essentially reduced to a very small range. You've got to get us involved. But more importantly, you have to be proactive from the very beginning.
One of the issues that you as young lawyers are going to deal with and be concerned with, as far as taking the bar and everything else, obviously, are your ethics. And we're beginning to see case law developing where judges are concerned not only about the rules being followed, but also about the ethical obligations that attorneys have. And plainly that goes to basic obligations that you as attorneys are going to have, and that's competence. And everything that the judge is talking about and I was talking about really is a function of your competence as an attorney and your understanding of what discovery is these days and how it needs to be conducted. And throwing into that also the concept we talked about a little bit before, which is proportionality, which is under Rule 26b2c of the Federal Rules, that requires judges as managers, and attorneys for that matter, to try to limit what they're doing and realize that there are limits to the type of discovery you should be asking, and the judges themselves have an independent obligation to make sure that there is proportionality in litigation. There's just a lot going on in this area that is an ethical level as opposed to just your professional competence levels and your compliance with the federal rules.
Yeah, I think Ron's point is absolutely essential. As fewer and fewer cases are going to trial, you now have to approach discovery, I think, with a view towards what is the least likely scenario. And the reality is, in today's litigation world, trial is really the least likely scenario. More cases get resolved either through settlement or through motion. So as you approach discovery, and particularly eDiscovery, playing off this notion of proportionality, what you've got to have a sense is what is the goal that you're working towards? What is your most likely outcome? And then come up with a discovery plan that leads you to that most likely outcome. Your worst scenario is spending lots of time and lots of your client's money to generate information that you will never use because the case just isn't going to go to trial. It requires you to look several steps down the road, anticipate outcomes, and then work towards those likely outcomes.
And I think you're going to be seeing judges as we go forward, especially judges at the federal level, as they become more conversant and comfortable with electronic issues, that they're going to grapple with these in a much sooner or earlier basis than you would have seen generally. A perfect example of that, although it's not the beginning of the process, is the Latham case out of the Eastern District of Michigan. There was a decision that just came out of there a few weeks ago where the judge essentially said, you guys have sidetracked discovery for 18 months, or trial for 18 months. Electronic discovery really is at the marginal stages now as far as getting information. You're getting close to have it not reasonably accessible. You've gotten it all on paper. And by the way, from now on, if you want this, you're going to have to pay for the other side to produce it. So.
Hey, go ahead. Sorry for that interruption.
No. The point I was going to make, and I think it sort of tracks what Ron just said, you need to understand that a large part of what you do as a lawyer is educating the judge about the particular challenges relating to your case. It's not enough to suddenly come into my court and say, Judge, this is unduly burdensome, or it's not reasonably accessible. You've got to come in and lay a factual basis for those assertions. You've really got to educate me. And when we're talking about the educational component, I think young lawyers here have a true opportunity. Folks like me who went to law school in the 70s, we grew up in a paper world. Our notion of discovery is, what can I find in a banker's box? That is becoming the exception, it's not the norm. And so what I tell young lawyers when I speak at conferences, you really need to go to law firms or employers and say, I feel completely comfortable with this technology. Take advantage of that comfort level and let me get involved. You want to go to a law firm and say, I'm comfortable with the technology, let me become an eDiscovery specialist. And I think you'll find that a lot of folks like me are more than happy to delegate that responsibility to somebody who truly knows what they're doing.
And there are plenty of opportunities for things to happen that are not good. And the perfect example of that is the litigation that's pending in Florida now, the Bray and Gillespie matter with the latest decision that came out not that long ago, where it appears that there were some problems on one side producing information and finding it. And I think as Judge Shaffer said, if you have someone young in early who understands what's going on, to the effect that there might have been misunderstanding in the production, there's an opportunity for a young lawyer to become involved, really work with his partners and who else he needs to, either the client level or whatever, and try to stop these problems from happening before they ever do.
That's right. And one kind of question, something we run into a lot. What if, how do you deal with a situation where one side, or sometimes both sides, are not comfortable with eDiscovery, and their solution is they're going to hire a vendor, which is going to be very expensive, and so they say, let's work with the case on a paper level and see if we can resolve it and get it adjudicated, and let's put off eDiscovery. What's your attitude towards that?
Well, I think to some extent a phased approach, and I think that's what you're alluding to, a phased approach to discovery makes sense. The real question is, again, what is the most likely outcome? If the most likely outcome is resolution either through motion or settlement, the real first phase of the discovery process has to be designed to get you the information so that you and your client can make a meaningful assessment of the risks. The information you need to assess risks is substantially less than the information you need to try the case. And so what I would worry about using a vendor, I think vendors can serve a real useful purpose. The problem is getting a vendor and then suddenly finding that you've jumped into the deepest part of the pool. So my advice would be use a vendor who's qualified, use a vendor that's reputable, but don't give up control of your case to the vendor. In the final analysis,